I call them the shields. So when your immune's good, your shields are up. Okay? When your immune's bad, your shields are down. So if your shields are down, disease is kind of like the bad guy. They come in and they shoot you down with your disease. So if your shields are down, you're a dead man. And when I say a dead man, it means you're going to get a cold, flu, sick, whatever you're going to get. What if your immune was up with your shields are up? So I want to give something to people and say, look, this is a proven deal. So if somebody comes to my website at getthetea.com, what a great website. No, I'm just kidding. If somebody comes to my website and you spend $60 with me on anything you want that you think you need for your body, I am going to give you a $62 bottle, 2-month supply of Allison Advanced. And what does it do? A lot more than just immune system, because watch your blood pressure. If you have blood pressure issues, you might want to try Allison Advanced. It helps you support in the normal range. So that's something that's really good. What about triglycerides or cholesterol? You might want to try Allison Advanced. Oh, wait, that's right. If you spend $60, you get it for free. Oh, there you see, that's the good thing. So, sometimes you'll see companies and they'll give away something and it's like, yeah, that thing never sells. Why don't you try giving that away to the people? So I thought I'd give something really good to the people, something that's good for them, something they can use for this winter coming up. It's already, the temperatures are changing. It's snowing like crazy in Colorado. So I thought I'd give them something really good. This is a Shields Up product. It's one pill. You ready for this? One pill is equal to 40 cloves of garlic. Now that's a natural strength. And so you can get this bottle free if you buy $60 with me on anything you want on the website, getthetea.com. And it will not show up in your invoice, but it'll show up in your package.
Is there a code for that or no?
Yes, Lisa.
Use the code Lisa. So, and I'll leave that all in the description box below too, but that's the thing. We're getting into blizzards and everything, and if, like you said, flu seasons, everything's upticking. And then the article that I showed at the beginning with...
Okay, so I think that's all I need to show on that. The important thing to understand is that the powers that be want to reduce the population. I think we all know that. Yeah. And there's good reason to believe that, next year there might not be enough food to go around, which means it'll probably go up in price. And so having some food storage is a good idea for those of us who can do that. Yes?
She mentioned the pigs. Actually, I've heard that half the pigs on the planet have basically died from the plague.
Swine flu?
African swine flu, supposedly. It is yet to reach here. Now, the 4 horsemen, one of them is the plague. Most people think, oh, we're talking about humans. No, the animals too, which ultimately is going to affect us.
Right.
So who knows, with that right there.
Right.
China, most of them were in China.
Right.
And they're scrambling now to keep their population.
Yeah. Well, and that's actually, that brings up another issue that I didn't even think of.
I mean, half the pigs of the world are gone. Just like that.
There's a video I recently circulated.
You sent, maybe?
Yeah, I sent it out.
And it's in your sent box?
It could be in my sent box. Should be. I sent it out to my group, so it should also be in my.
What's the subject of the?
There's a. Let me think. Oh, I bet I know where it's at. Oh, let's click on. It was another Bixwer video, but it was talking about how China, there's runs on banks in China.
So that. You sent that yesterday, yes?
Yeah.
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 Chinese bank run.
There's a Chinese bank run.
Hold on tight.
Right, right. Yeah, exactly. And so, there's no reason to watch that video, but the point is that there's already Chinese bank runs, which means that banks are collapsing in China, and there's going to be some,
Ripple through.
ripple effects. That's right. That's right. And so you know that it's coming here. I mean, I'm thinking it'll probably hit over Europe first, like with Deutsche Bank. Some of the bigger banks that are getting ready to fail
They
anyway.
said Deutsche just dropped by 8% or something last week.
Is that right?
Yep.
Yeah.
So yeah, I mean it's
So it's coming. It's getting ready, and so we all need to do what we can to prepare for ourselves and our family. I know I've got a bunch of food storage. I got it on land that I own, so
you got to secure that too. So you got to start thinking holistically too, right? It's not just having the food, but now you've got to defend that food because when nobody's got it,
right,
they can be coming to look for
well,
you.
It's out in the country. So, but I remember I had a dream one time that I traded a bucket of wheat for somebody's house, and it might come to that. So, anyways.
Order a few more bags of moringa.
So we might as well start.
Chia seeds also are very stable and they last, and they're very nutrient dense.
What's that?
Chia seeds.
Oh, chia seeds, right?
Right. You can store them forever. They're
Right.
just a seed, but
Right.
the story is that I think Aztec or Inca warriors, whenever they went into battle on long treks, they would carry they'd carry a sack of that with survival. I guess they would supplement it, but that was one of the main things.
Well, when I was a kid, I met this old lady, was down the street, and she would take a cup of wheat, and she'd put it in some water overnight, and it'd swell up.
Yeah.
And in the morning, she would add honey to it, or brown sugar, and that's what she'd have for breakfast. And, I mean, that'd be a good breakfast. And it was nice and soft. It was chewy. You know what I mean?
Yeah.
And
That's
it'd be
the
filled.
original wheat, though. I wouldn't want to touch any of the current stuff.
Well, the current stuff, yeah, that's right. But, so, anyways, this one is going to be on third-party debt collectors. This is actually, I modified another video I did because I had dealt with some third-party debt collectors. This is number 5, and number 4 is similar. Okay, it's got some material out of this one. Matter of fact, I think number 4 I did last time, or the time before. It was one of the two. But it was about third party. But this one's going to be way better. This one, first of all, I'm not a liar. Well, I meant a lawyer. Oh no, I meant a liar. You should never take my word for anything. You should always do your own research. I provided aid to you do your research, but I don't know everything, and I'm open to any ideas. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? There's another phrase or way I've heard of it said is there's people that make things happen, there's people that watch things happen, and there's people that wonder what happened.
I like
So hopefully we're the ones that are watching it happen at least. You know what I mean? Anyways, if you can see through the illusion, then you are the solution. And it is an illusion. If the people do not know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the cops. And that's true. If tyranny needs to gain a foothold, all tyranny needs to gain a foothold is for people of good conscience to remain silent. So this is a friend of mine that has this website. Now that address is perfectly fine, but the email address is no good. Well, he checks it. The email address is good, actually, but he doesn't ever hardly check it that often. And I'll provide the email at the bottom, okay, dbs81@yahoo. That's how you contact him. If you're interested in the stuff that he has. he has a 100% success rate with debts. Okay. Now I can tell you he's only been in court once, and I know that it's mostly dealing with third-party debt collectors. I don't know if he's actually dealt with the original creditors, but I know that he's with third-party debt collectors. They're easy. Okay. And he actually provided me with a letter that I can use, that I can tell you about, that he uses. But if you want his help, he's available. He helps people all the time. Well, I wouldn't say he helps them all the time. He really hasn't pursued his website that much. But if people contact him, he does help people all the time. People like, there's a guy that, a friend of his that I happen to know that sleeps in his truck, and he helps him. He goes to court for him, helps him, that's what happened. Was this guy got I think it was a speeding ticket. I can't remember. It was some sort of ticket, and so he coerced me, because I don't like the guy, quite frankly, and he coerced me into preparing some paperwork for him. So I did. I prepared some paperwork for him, and we served it on the judge and the county sheriff. What happened is he showed up in court, and they immediately wanted to plea bargain the thing, and he immediately went and plea bargained it, and that's the worst thing you can do. And since then, I think he's got him trained now, because he doesn't plea bargain it, but he still gets these tickets and stuff. And this friend of mine will go in court and they'll drop the charges, okay? And so this is with tickets and stuff like that. He goes into court and helps them all the time. So this is regarding debt bills, not tickets, okay? One thing about third-party debt collectors is there's no application, okay? Now, even with the original creditor, there's no contract. Okay, it's an application form only. There's never any contract. It's just an application form. Now, there must be offer acceptance consideration, and they send an insertion in a bill that you do not sign, and that's not a contract. And so then another question you ask them is, so with these third-party debt collectors, is where produce a signed contract, you know what I mean, showing that I've agreed to something. And then how much did they pay for the alleged debt? Because that's another thing you ask them for. How much did you pay? They have to show you that, and they're only entitled to get what they paid, right? Otherwise, that's unjust enrichment. That's what that is. And so. And the statute of limitations is 2 years from when you stop making payments, okay? And usually the original creditor is going to keep it for 6 months to a year at least before they sell it, and then the third party debt, it's almost always beyond the statute of limitations. And
sorry, Glenn, can I query that a little bit, because I did research on that, and I think there are certain states where it's 5 or 6 years. Typically.
Oh, really?
Yeah.
That's possible. I know in Texas it's 2 years.
Yeah.
I think so
we might want to look. Make that dependent on the state.
That could be,
because I think
that could be some states.
But I looked at it, and the average was about 5 or 6 years.
Wow. Well, even then. So what you do is you get them to produce evidence that it's not within, that it's or at least. Swear an penalty of perjury that it's within the statute of limitations. You see what I'm saying? And there's a bunch of things you can do in that respect. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steam at Sovereignty International. Don't forget to like this video on YouTube. Don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steam, don't forget to vote and make your comments. That's my front page of my channel. The subscribe button's already been clicked. The bell has not been clicked, otherwise it would look like it's vibrating. And the arrow's pointing at the bell, you have to click the bell. So this is actually a solicitation I received from some third-party debt collectors. What they did in Texas, at least, is they increased the amount that you can sue someone in small claims court up to $25,000.
Where is this now?
This is in Texas.
Oh, really?
Yeah, so
That's
you can sue someone for up to $25,000 in small claims court.
That's the highest number I know of, because
Yeah.
in Pennsylvania it's 12,000.
Right.
In Jersey it's only 3.
Yeah. Right. So that makes it harder.
Pardon?
Is it not flat?
I don't believe so. I think it's only $3,000.
No, I think it's 5.
Is it 5?
I
That'd be
think
good.
it's 5.
Well, 5's not bad, but 25,000.
Yeah,
I mean, in that way you could almost drag a cop into small claims, and that's as close as you're going to get to the common law, because he's not allowed to bring a lawyer, and you're not either.
Right.
Just the person who's sitting there. Him, yourself,
That's true.
and the other one.
That's
So,
true.
the
Small
closest
claims court is the closest thing to common law.
I'm the closest thing you're going to get.
Unless the
you
other
take-
party is a lawyer,
Well, you
Yeah.
take one.
which is what they find.
Well,
they are.
you take the guy who wrote you the ticket. Prove to me that this was on federal land. You can't prove it. Oh, or if he doesn't show up, it's automatic. He's
Right.
screwed.
Anyways, this is a solicitation I got from some liars in Texas. It even says advertisement on it. This is another one. This was over the same issue. Portfolio Recovery Associates. And this is another one. It's all over the same issue. And look at this. What it says here. This was in 2018. It says, whoops, okay, let's go back and look at this. It says that this Portfolio Recovery Associates says you may not have received this lawsuit yet. Well, if I haven't received it, then they haven't served it, have they? And they have to serve it. With any lawsuit, they have to effect service. And if they don't effect service pursuant to their rules, then they've got a defect. But if you show up, then you have cured their defect. So you have to understand what the rules say, and if they haven't effected service, do not show up. If you do, you cure their defect. Anyways, so that's one reason I have a private mailbox. The only address I ever give out to anybody is my private mailbox. That's the only address. And so anyways, they all say advertisement. They all say Portfolio Recovery Associates LLC. And they all have a case number filed with the Justice of the Peace. And, here it is up close. So here's the Portfolio Recovery Associates in Tarrant County, JP number 4. And it says, you may not have received this lawsuit yet. After a lawsuit's filed with the court clerk, it must be delivered as called. Yes, I know. And then it's called an advertisement. But they're trying to stampede me into appearing. That's what they're trying to do. And check out my contact information is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page got deleted due to censorship on the part of Facebook. My private group, Sovereignty International, is being deleted. It takes time to ban 17,000 people off your group. Matter of fact, I have someone else. I don't even go to Facebook anymore. That's a has-been. My Yahoo private group is called Administrating-Your-Public-Servants. My Google private group is called Administrating-Your-Public-Servants. Follow me on Twitter at Engineer Win. Follow me on Steemit at Sovereignty International. BitChute, I've got a BitChute profile, but they only allow me to upload up to 500 megabyte videos, and so, a lot of my videos are more than that, so I don't even have I haven't been on BitChute for a long time. And Patreon, I've got a Patreon channel too as well. Anyways, this is the Texas Rules of Civil Procedure. So the most important thing, I'm going to also do a presentation on the rules on filing a lawsuit. Okay, and that's another thing that I'm planning to do probably maybe later today or tomorrow or something like that. And I've got some example lawsuits and things to consider. But it's not all of it, not of everything, because there's a lot of variables. There's going to be more than one video on lawsuits. But anyways, so this is Texas Rules. When I first started doing this, back in the mid-90s, okay, so that's what, more than about 25 years ago, the rules were like about 100 pages, okay, which is bad enough, quite frankly. Now, if you go like the Texas Rules of Civil Procedure is like 700 pages. And so it's a bit of a nightmare trying to figure all that stuff out. But, you know, again, rules are for lawyers, and this is what we'll talk about in the lawsuit. And I deliberately don't follow their rules in a lot of cases and let them complain. You know what I mean? And they'll tell them, I'm not a lawyer. I never, you know, but if you want to affect service, you better follow their rules. Anyways, so that's where the service comes in, right? Service, including a citation or the notice, writs, orders, and other papers issued by the court, may be served anywhere by a sheriff or constable or other person authorized by law, which means a process server. Any person authorized by law or by written order of the court who is not less than 18 years of age, any person certified under order of the Supreme Court. So basically, sheriffs, constables, or a process server is really the only people that are authorized to do it, to effect service. And so, under their rules. And so, method of service. Unless the citation or order of the court otherwise directs, the citation shall be served. Notice it's a citation, right? That's Roman cult. Okay, that's exactly what it is. Shall be served by any person authorized by Rule 103, delivering to the defendant in person a true copy of the citation with the date of delivery enclosed thereon and a copy of the petition attached thereto, mailing to the defendant by registered or certified mail, return receipt requested, a copy with a copy, and if you read down here further, only the clerk can do the mailing. Upon motion supported by affidavit stating the location of the defendant's usual place of business or usual place of abode or other place where the defendant may probably be found, and stated specifically that the facts show that the service has been attempted under either A1 or A2 at the location named, and by leaving a true copy with a copy of the petition attached to anyone over age 16 at the location specified in such affidavit. So you can actually, if someone has trouble, if they really want to get you, they'll go to, that's a lot of trouble, but depends on what the issue's over, okay? These third-party debt collectors want it nice and easy. So, I mean, they don't even really affect service most of the time. They don't do it, they don't follow the rules, and so you don't even have to appear. If you appear, I can't tell you how many people call me up and they're dealing with some third-party debt collector. And my first thought is, I'll bet you they didn't even affect service properly. And they volunteered. They cured the defect by appearing. You see what I'm saying? And so you don't panic. You got to get into those rules and see what the rules say, because they probably didn't affect service properly. Because, you know, I didn't show up. I didn't appear. And those cases all disappeared. Never heard another word out of it.
Yeah, that happened with Tara last year. She, because of her ex-husband, the situation with the house that they lost because of his stupidity, but basically there was somebody who ended up going back to the house in winter, left the water on, heat, froze, burst pipes.
Oh, you kidding.
Tenement, so it flooded the neighbour.
Oh, wow.
So nothing to do with her, but the house was in her name. So a little later on, she got a lawsuit, filing for a lawsuit for damage from recovery by the insurance company. But they didn't even file proper paperwork.
Right.
It was just a notification.
Right.
You're being sued.
Right.
You'll hear something from the court. You got a freaking postcard sent. Appear at this room number, whatever. Court.
That's not service.
Oh, and it was nothing. So I actually did send them a letter back initially, just to challenge the jurisdiction. They sent something else back, which I just returned. And then the court date appeared and went by, and then they sent another letter that said, you may know that there is a default judgment against you, blah, blah, bullshit. Please contact us to arrange payment. So I actually sent a red letter notice and returned that to them with the
mail
red
fraud.
letter notice.
Right.
Mail fraud. Went away, gone. Never heard a damn thing. Check the records, there's no court record, there's
Right.
nothing.
Right.
Disappeared.
It's all a fraud. So again, once you understand the law and what they have to do to satisfy their requirements, they rarely, I think, even in these criminal cases like the traffic tickets, this friend of mine goes in and helps people with traffic tickets all the time, and he says that they deliberately, like there's statutes of limitations on due process. They have to do a speedy trial, and they never satisfy that. It's never within the time limits, and so you can always get it thrown out for one reason or another, but most people don't know. They want somebody just to write them a check. You see what I'm saying? It's all about theft. That's what it is. And they're just a bunch of thieves. And again, the return of service. Yeah, so this is just more stuff about the return of service. And whoever serves it, okay, this is the return of service. So this has to be on the record, in the case. Has to be filed into the case. So any court case is public. So you can go down there and you say, I have this case number, I want to see all the filings in it. You don't have to tell them who you are. It's none of your business who I am. I want to see the filings. This is public. You see what I'm saying? And so you could see if it was properly served. And right now I have a couple friends of mine that I'm actually helping over. It's actually one of them. They appeared. Well, they went and they did some stupid things, and first of all, you never ever put your home address on anything, and they did. And so they went and found them at their house, and it could have been service, I don't know. Again, you'd have to look in and so anyways, in one case, we filed a general denial, and I do a lot of lawsuits, quite frankly, and this friend of mine, this guy that, he does a lot of lawsuits. And so I help him with them, and because he's not very computer literate, it's all electronic filing now. And so I help him. So I have copies of everything he files. That's on my computer. And so, matter of fact, I'm going to, when I do the do-it-yourself lawsuit, I'm going to have a lawsuit where it's actually a malpractice lawsuit against some lawyers. And it's just a lawsuit though. But it's I got a bunch of it redacted out of there so that you can't see, who the parties are and all that stuff, but or the case number. But everything else is there, and so we'll be going through that maybe later today or tomorrow or something like that. I know you were going to do a presentation. How long do you think you're going to need?
If I do the rights of travel?
Yeah.
I could probably do that in an hour and a half, I guess, depending on how many questions there are.
Right.
We don't have a full room.
Don't have a full room. Yeah. Okay. So and then I know Chong was going to do a presentation. So that I guess between the two of you might be a half a day or 3/4 of a day. I was going to get Chong because he's got some interesting stuff that. I'm actually I'm going to do a presentation on some of that. I've been doing some research on it, and some of it is 100%. The rest of it, until I do the research, and you know what I mean. I don't just accept stuff, and I don't make videos about stuff until I know that it's something that's worth doing. But so far, he got some stuff from Geraldo from Rivera. Edward Rivera, yeah. Geraldo Rivera is the news reporter.
That's your source, huh?
Edward Rivera is a law professor, and it's very interesting. And so and some of it I'm definitely going to do some YouTube videos over. And so I'll let him present his stuff, and then you guys can come to your own conclusions, and hopefully it'll get some people doing some research, because it's definitely worth considering. And the more I do the research, the more I find out that it's 100% correct. It just takes time for me to do the research, Anyways, so there's things that when they affect service, they have to file a document into the court, and this is what they have to put in there. Okay, the return together with any documents to which it's attached must include the following information: the cause number, the case number, the court in which the case is filed, the description of what's served, the date and time the process was received for service, and the person or entity served. So they have and then the address served, the date of service, attempted service, the manner of delivery of service or attempted service, the name of the person who served or attempted to serve the process in the service. If the person served in 9 as a process server certified, or order of Supreme Court his or her ID number and the expiration date of his or her certification. And so the point is that there has to be a bunch of stuff in there. It's got to be a affidavit, okay? Affidavit of service. It's got I served this, and who he is, and all that stuff. You see what I'm saying? And if that's not in the case, then they have an effective service. Again, this is all stuff you need to look for.
Now, just on that, can registered mail?
If it's done by the clerk.
Okay, so we can check both then.
Yeah. Well, again, if it was registered mail, there would be something by the clerk. Anyways, so some foundational things to consider that I do. Okay, because again, I've been sued before, and so some foundational things that if you're going to do lawsuits, and this is stuff we're going to talk about when we do the lawsuits too, because if you're going to be suing other people, there's always the potential that you're going to be sued, or you might be hit with costs and that kind of stuff. You see what I'm saying? And so some foundational stuff is, did you make sure that nothing is in your name as suggested in my videos? Okay, I don't have anything in my name. Okay, my car is not registered, so it's not in my name. There's nothing in their system that's in my name. There's stuff that I have land that's under Glenn Winningham House of Fern, but that's got the land patent on it, and they can't touch that under any circumstance. As a matter of fact, that doesn't show up on any tax records or anything. Any land that's in my name doesn't show up on any tax records or anything. And I've got several parcels of land actually that I brought forward the land patent on. Did you make sure that anything that you cannot transfer out of your name is heavily encumbered? Okay, so in other words, if you do have a car in your name, put a lien against it. Use and this is where structures come in useful. Trusts and those kinds of things can be useful to do all of that stuff. Trusts can be used to make sure everything is heavily encumbered, but you don't necessarily have to use a trust. But if you use a family member and it's obvious, or they can figure that out, then they'll pierce it. Okay, that's why a trust is so much better for that kind of stuff, because if it's done properly, it's going to be untouchable. Anyways, encumbering property must be dealt well in advance to defeat any potential fraudulent conveyance allegations, and that's true. So if you do that, like I've heard that 4 years, if it's past 4 years, then there's going to be no fraudulent conveyance allegations that are going to come out, because it's well past. The way they look at it is if you convey something and it turns you into a pauper, and then you get sued. Okay, so if it's within 4 years, then it's going to be under scrutiny. But the closer it is to the time that you get sued, the more under scrutiny it is. You see what I'm saying? In other words, if 2 weeks before you get filed a lawsuit, you all of a sudden started transferring stuff out of your name, well, that's going to be, they're going to be looking at that, I guarantee you. So, anyways, so some other problems is a third-party debt collector. Third-party debt collectors have no standing to do anything. Is your contract with them? Third-party debt collectors need you to be ignorant of the law. They're fishing, that's right, they're fishing. They're trying to reel you in. And if you go and show up in this case, then you took the bait. That's exactly what happened. The particular alleged debt in my case was around $1,500. The Justice of the Peace is small claims court, and they raised the limits for small claims courts up to $25,000 in Texas. And their attorney fees can be at least $1,000, so the attorney's probably keeping all of it, or most of it, and probably way more. Don't you think these liars do searches for assets that may be registered under the Strawman's name? Of course they do. They're going to find out, is there anything to steal in this case if we have a problem? Yes.
Small claims in Texas, you can bring an attorney in?
Well, certainly a creditor, a bank or something like that, third-party debt collector, they have to have a lawyer.
Okay,
see what I'm saying?
Send in. Okay. in their place.
Yeah. They have not affected service. The only address I've used in over 10 years is a private mailbox. They don't know where to find me to affect service. Small claims court is the closest thing to a common law court, and effective service is a big problem. If you appear, then you correct their defect. I have subscription and Patreon channels. I have exclusive content available on my website and also on Patreon. My website has 2 subscription levels, and I accept cryptocurrencies. My basic subscription level is $29.99 a year for the videos only. My platinum subscription level is $49.99 a year for the videos plus unlimited consultations. Now, I have limits as far as my unlimited consultations are concerned, because I'm not a liar. Well, I'm in a lawyer. No, I'm in a liar. But I can tell you what I would do under certain circumstances and where to find the forums. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need people fighting the same battles, using using proper arguments as well. I'm currently publishing a video a week, and it goes up and down because I'm really not interested in publishing stuff that I've already published. So if I don't have something new to publish, then I might go a week or two. These videos will be up, ultimately will be on YouTube, but they'll be on my exclusive content and my Patreon content first for a period of time. Some of my exclusive content is Arlington Private Information Share. That's 9 videos by itself. My land deed training, my estoppel certificates training, my foreclosure estoppel certificates training, my corporate denial training, my toll roads notice and demand training, my invoice training, my notice of void judgment training, my revocation of signature training, my third-party witness training, my federal habeas corpus training, revocation of voter registration training, criminal complaint training. There's several videos about criminal complaint training, and there's going to be more, because I'm learning new things about how to do stuff. You know, you have to understand that, especially with criminal complaints. Remember what they did with Hillary Clinton? They redefined what she did, and they said it was extremely careless instead of, what does the statute say? It's got to be grossly negligent. So they instead it's extremely careless. Okay, they just didn't use the words in the statute. So you got to use the words in those statutes. And so lawsuit training, I have one video that I'm going to do this week that'll be available, and there'll be other ones. Again, there's going to be multiple videos about lawsuit training as well. Other training requests, if it's something that I can do, I'm open to ideas. Also, the Northeast Private Information Shares are going to be on my exclusive content, at least for a period of time, until I publish them on YouTube. All forms, files, and other instructions available for free in my 2 private groups at Yahoo Groups and Google Groups, and all exclusive contents available on my website, and you can buy a subscription there. Now, and if you want to subscribe as a donation, it's a modest donation, there's no doubt, but a whole bunch of people chipping in a little bit, it adds up pretty quick, and it's all appreciated. Oh, and then there's also a Patreon channel, Sovereignty International on Patreon. So anyways, this is that letter, and you may not have received this lawsuit yet. After a lawsuit is filed with the court clerk, it must be delivered, and they haven't served it. So their process, including a citation, other notice, writs, and other orders, and other papers issued by the court may be served anywhere by a sheriff, constable, or other person authorized by law. This is Rule 103. Any person authorized by written order of the court who is not less than 18 years of age, or any person certified under order of the Supreme Court. Service by registered or certified mail, and citation by publication, if requested. Must be made by the clerk of the court in which the case is pending, but no person who is a party to or interested in the outcome of a suit may serve any process in that suit. And that's important. Okay, so if you're interested in it, if you're the guy that filed the lawsuit, you cannot serve it. You have to get someone else. That's called due process of law. They have a right to due process just as much as you do. And that's fixes rules of civil procedure 103.
So that's regardless if you're responding to something and you need a paper trail of that and you serve it back. How does that?
If you're responding to something, you just file it with the court.
Okay.
You file it with the court, actually, the way you respond, if you're going to respond. Even in a criminal case, okay, you file your originals go with the court and copies go to your opponent, whoever, if it's the prosecutor or the defendant. If you're suing them, they're the defendant. If they're the prosecutor, then you're the defendant, and you still serve the original on the court, and a copy on the prosecutor or defendant.
You're serving it on the court, or you're filing it on the court?
Well, once service has been effected, if you read the rules, then you can just use first-class mail. They'll give you an address to serve it on, so you just serve it by preserve. But you have to have an affidavit of service. When we go through the thing about the lawsuit, you got to include an I hereby certify that I served this on at this date and time, sort of thing, by first-class mail.
I went through.
But then in effect, aren't you party of this effective service? If you're doing
No,
it by mail?
no.
If you, well, once under the rules, okay, this is their rules, okay, so under their rules it says you can use first-class mail for after the initial service, after you've appeared or they've appeared, then you can use first-class mail, and that's all that's needed.
Okay,
after the appearance, okay. If they don't appear, in order to get them to appear, you have to jump through the hoops, okay. But after that, it's just first-class mail. You read the rules; it'll tell you that. And so, and then there's all sorts of rules. I mean, they have 700 pages of rules, right? So you file a lawsuit. Usually, the rules will tell you that you got like maybe 30 days to serve it on them, or maybe 4 months. Like in the federal courts, you have 4 months. You can serve it on them within the next 4 months. And so it depends on the rules. You got to read the rules. The rules will tell you everything. And but what I deliberately do not follow the rules, and like they say, it has to be double spaced. Well, I might make it space and a half. And if they want the font a certain size, I might make it a little bigger, a little smaller. How are they going to tell anyways? But there's a lot of stuff I don't follow their rules. And if it becomes an issue, sometimes the court won't accept it if you haven't done it properly, at least as far as and so then the court will kick it back to you and tell you, well, you need to do it this way. You know what I mean? But I never ever go and ask the court anything. Okay, I'll serve it and let the court come back and kick it back for some reason. And if you're not a lawyer, the courts are usually very helpful. Okay, matter of fact, there's these friends of mine that
up to giving legal advice.
Yeah, well, they'll say, "Oh, we're not giving legal advice, but this is what you do." but this friend of mine that they got sued. It was like $2,500, right? Third-party debt collector, and so I took him down to the court, and we walked in, and this was a justice of the peace, right? So there's no security, nothing. You just walk in the building, and there's their counter right there, right? And so we walked up. And I said, I give them the case number, and I said, we just got this thing. These are my friends. I'm not them. These are my friends, and I'm just trying to give them a hand here. And I said, we would like to continue this thing so we can file a response. And so then the clerks basically said. They looked into it. I said, there's a hearing scheduled for 3 weeks from now, and so we need more time. And the clerk went and talked to another clerk, and they came back and they said, yeah, that's no problem. The judge will grant that. They'll do one continuance for each party without any trouble at all. And so we just need more time because we're going to respond, and we're going to do a discovery, right? General denial and a discovery. And anyways, so that's what we did. And so we got to file. I went and sent my discovery documents, and it's basically going to bring up all the questions that we already talked about and more. And but I'll bring up, it's all in this letter that we're going to talk about here shortly. Okay, for third-party debt collectors, it's all the same stuff. And you basically put them in the position that, you know, they're only getting $2,500. Is this worth all this trouble? You know what I mean? Because they got to go and start scrambling to get this information, and you know, you want them to drop the case, right? So anyways, so this is again Texas Rule 106. We already talked about this. Delivering to the defendant in person, I think we already talked about this. This is Rule 107, affecting service. The officer or authorized person executing a citation must complete a return of service. The return may but not need to be endorsed on or attached to the citation. The return, together with any documents to which it is attached, must include the following information: the case number, the cause number, the case name, the court in which the case is filed, the description of what is served, the date and time the process was received. Now this is Texas Rules of Civil Procedure. It's not any other state. So every state's going to
Be similar, but
different.
They typically have their own form which you just fill out and sign, and then usually it's sworn at or when we filed it at the court itself, you can swear it in front of the clerk.
You're right. Yeah, oh, of course.
And then
Yeah, because
they
they're all
accept it and file it as
Right.
part of the case.
right. And at the bottom here it says, when the citation is served by registered or certified mail as authorized by Rule 106, the return by the officer or authorized person must contain a return receipt with the addressee's signature. So again, right? Remember that green card? If they don't get your signature, that's a problem for them, right? Don't sign those green cards. Don't even accept service. Let it expire and it'll go back. See what I'm saying?
Doesn't that, at that point, I mean, in cases I've been in the past, many years ago, the fact they served it and it wasn't accepted, they still proceeded. Is that just because it was a criminal enterprise?
They may. It depends on their rules. You'd have to look at their rules, you know. If it's like a private mailbox, well, how do they know you really got it then? You see what I'm saying?
Yeah, they just continue on anyway. Right?
Well, they might. Again, if you have something in your name that they can steal, then that might be a problem. If there's
Right.
nothing in your name, who cares?
Right. I mean, that's where I'm at right now. So
Yeah.
back then, I was still creating wealth in my name at that
Right.
point, which was
Right.
a mistake
Yeah,
because it gives them a target to shoot.
absolutely. They're thieves.
Yeah, process servers and the like, typically, they'll just leave it on the damn doorstep and say that they served it.
Preach.
I mean, they're not even allowed to do that. Literally, they have to. Even if you refuse it, because I was served several years ago, and the process server said, "You might as well accept it because I'm just going to leave it on the doorstep, and you've spoken to me and
Right.
say that I've served it."
Right, right.
Well, you don't know who I am. I've not said who I am. This is the address.
If
There's
you've got,
somebody here, and I'll leave it on the doorstep.
right, you're
And
over
so-
16.
Right.
Right.
So,
Yeah.
what do you do?
Yeah, right. Many times there are defects in service, and if you panic and respond, you cure their defect. I have received unfiled lawsuits. All lawsuits are public, and anybody with a case number go to the court and pay the fee and get copies of filings. And this is under Texas Rules of Civil Procedure, Rule 107. It says it's about default judgments, and this is what their requirements are for a default judgment. No default judgment shall be granted in any cause until proof of service as provided by this rule or by Rule 108 or 108A, or as ordered by the court in the event citation is executed by an alternative method under Rule 106, shall have been on file with the clerk of the court 10 days, exclusive of the date of filing and the date of judgment. So, again, there's requirements even for a default judgment. And so, again, you have to get familiar with these rules and see what they say, and you'll know what the issues are and what you're dealing with. You see what I'm saying? And so They have requirements even for their default judgments. There's nothing, bottom line is that there's nothing in their strawman's name, there's not much they can do. I do not use a social security number, they've not affected service, they don't know where.
But one can, as a man, agree to let them try you, which is foolish, but you could do that, right?
As a man?
Yeah, as the...
Well, first of all, it can never be the man, okay? That's why they say actor, okay? And even in their statutes, the actor has to appear.
Under the Clearfield
Well, they'll say
Doctrine,
persons, right?
That's persons, yeah, it's
Yeah.
actors.
well, the dead cannot speak to the living. And the Act of 1871 created a federal corporation. Corporation is a dead thing. So they can't speak to a living man. Even the Clearfield Doctrine says that doubles down on it in the fact that the real money supply disappeared. So as soon as they do that, they're playing with personal paper, private commercial paper. Then they also lose the being a real government by the people. They're now a corporation. They have to do business by contract, and that also makes them a dead thing. They can't speak to the man. Clearfield Doctrine has been mentioned several times in some of his stuff.
This is, again, this is the one we made up, the handwritten one. And they ultimately dismissed that case. So back to
Now, do you think it was because of that just simple
partially.
declaration, or
Partially.
because of other paperwork? that
Well,
was
he didn't.
submitted?
He never did. He was. First of all, it's a long story, but the judge. This friend of mine is a businessman in Dallas. He's never ever worked for someone else. He used to own like a chain of 30 cell phone stores in the DFW area. He used to own some in New York, Florida, and California. Okay, and he shut them all down because there's just no money in them. And so the judge in that court used to work for him.
That's how we got on the inside.
So he's lived there forever. They know who he is. You see what I'm saying? And so that's probably part of it. But he was basically refusing to. He said in the past he'd walk in there and they just dismiss it right off the bat. It's the same judge. The same judge. He's known that judge forever. He knew that judge. The judge worked for him. He was going to law school, and then he wound up being a judge. And you see what I'm saying?
He must have accelerated fast to get to a judgeship.
Well, who knows? You know, it's a lot of times I suppose maybe it was just knowing the right people. You know, I mean, this friend of mine his dad used to hobnob with the mayor in Bedford all the time. Okay, well his dad's dead, the mayor's dead. Now there's a whole different regime there. But so probably that lawyer used to hobnob with them all too. You see what I'm saying? And so that's how he wound up being a judge. Who knows? But so he used to own all these stores. Now, you know, me and him go to the flea market on Sundays. That's the only day that he has available. He's a caregiver for his 8-year-old mother. And you know, this is the only day he has available to work, to do anything, to make money. And I help him. That's where I make my money, besides from my YouTube channel. But but he's known people there forever. He's been in that town. He went to high school there, and now he's in his 50s, I guess. And so, anyways, for what it's worth.
Just for, I don't know, everybody else probably knows, but certainly the signature on that document as well is how I sign and how everybody should sign.
Well, it's a mark. It's a mark.
Well, it's not just the signature itself, because signature and autograph are two different things, but I'm more referring to the proceeding and the post.
Well, yeah, hidden within signature is sin, because to owe someone is a sin, and that's what these guys in Australia have been finding, have been uncovering. Sin is built into signature. It's a sin, you know. Basically, they're talking about the contracts, and it all goes back to admiralty.
Yeah. It's all satanic. It all goes back to the Roman cult. Admiralty goes back to the Roman cult.
So if if a man enters into a contract, he's signing under his proper name, which is his fictitious entity, correct or not?
You should, like you said, you should print as a man, really.
Print
Yeah,
as
you
a-
should print the name.
You should be printed.
Well, and you can only enter into a real contract with another man. Okay, in other words,
Yeah.
if you're going to enter into a contract with a corporation, then really the contract should be between you and the CEO of that corporation. You see what I'm saying?
If you've got glasses or need glasses, that's a description of without prejudice and what the signature actually is. Because
So-
the signature is actually just a mark.
Yeah, exactly. It's a mark. It could be an X.
Exactly.
It could be anything.
All you're
Yeah, I
doing
like
is
it.
authorizing the document.
So if a Class C misdemeanor fails to be a crime, that is by definition a civil matter, which means it's an extortion racket. And this is Texas Transportation Code 707.019. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued. And the imposition of a civil penalty may not be recorded on the owner's driving record. In Texas, a police officer may not arrest you for a Class C misdemeanor, and if they do, it's false arrest. The only thing the plaintiff needs to do is allege a false arrest. To allege a false arrest is either one, that the defendant made an arrest or imprisonment, or two, that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. So it's false arrest. But remember, they're saying when the plaintiff, okay, that means you got to sue him. The burden is upon the defendant to show that the arrest was by authority of law. Texas Transportation Code, well, I already talked about this. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty, an arrest warrant may not be issued, and imposition of the civil penalty may not be recorded. And what they do in Texas actually is capias, okay, which is a bench warrant. And a capias is not a warrant of arrest. In this chapter, a capias means a writ that is issued by a court having jurisdiction of a case after judgment and sentence. They cannot issue a capias until there's judgment and sentence, and they do it all the time. I filed judicial complaints against them, and I'll bet you I'm getting them in hot water big time. Capias pro fine means a writ that is issued by a court having jurisdiction of a case after judgment and sentence. And a capias is not a warrant of arrest. If a cop stopped me for speeding in Texas, I'd say, I don't have a problem providing whatever you need, but I've got a couple questions first. Actually, probably what I'd say is I don't answer questions. I like that.
I'll go into my sequence.
Yeah.
When you
Yeah.
get pulled over.
But anyways, in this I'm saying, but I got a couple questions. First, what's your probable cause for stopping me? And if he stopped me for speeding, he'll say that. And I'll say, well, speeding's a Class C misdemeanor, and a Class C misdemeanor is not a crime in Texas, and probable cause requires a crime. So I ask you again, what's your probable cause for stopping me, or should I just be on my way?
Love it.
Then I would dial 911 and tell them I need a county sheriff there because there's some official oppression going on. And official oppression, this is abuse of official capacity, and a public servant commits an offense if with intent to obtain a benefit or with intent to harm or defraud another, he intentionally or knowingly misuses government property, services, personnel, or any other thing of value belonging to the government that has come into the public servant's custody or possession by virtue of the public servant's office or employment. When he turns on his emergency lights and there's no emergency because a Class C misdemeanor is not a crime, so he can't claim there's an emergency. When he turns on his emergency lights, that's a misuse of emergency equipment. Plus, he's probably searching database for that license plate. He's probably doing all sorts of stuff. That's all misuse of all of that equipment. And how much is that stuff worth? According to under this 3902, if it's worth less than $100, I think that it's only a Class C misdemeanor. But if it's worth more than that, it goes up based on how expensive the equipment was that he used, that he misused.
Is that right?
Yeah, that's in Texas. And then what they always do is they use this Texas Penal Code 3802, failure to identify. A person commits an offense if he intentionally refuses to give his name, address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. Well, first of all, if there's no crime, you haven't lawfully arrested me. And you're not, and plus if there's no crime, you're not a peace officer, you're a law enforcement officer, and so that doesn't apply. And then official oppression. A public servant acting under color of his office or employment commits an offense if he intentionally subjects another to mistreatment or to arrest, detention, search, seizure, dispossession, assessment, or lien that he knows is unlawful, intentionally denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity, knowing his conduct is unlawful, or for purposes of this section, a public servant acts under color of his office or employment if he acts or purports to act in an official capacity or takes advantage of such actual or purported capacity. So he's not operating in his official capacity, he's in his private capacity as a revenue officer is what he's doing. And so that's official oppression.
Federal Tax Lien Act of 1966.
Yeah, exactly. Texas Penal Code 3711, impersonating a public servant. A person commits an offense if he impersonates a public servant with intent to induce him to submit to his pretended official authority, to rely on his pretended official acts, or knowingly purports to exercise any function of a public servant or a public office, including that of a judge and court. And the position or office through which he purports to exercise a function of a public servant or public office has no lawful existence under the constitutional laws of the state or of the United States. And that's a felony.
Just go back a second. Now, where it says there United States, should that not be lowercase u?
Well, all judges are U.S. citizens. All the courts are federal. I don't care if it says federal or state.
Yeah,
They're
but
all
you're saying
federal.
that
United
there's no
States
lawful
is a-
existence under the Constitution or laws of this state or of the United States.
Right.
That's
So,
referring to the Constitution.
That would have been before the
Yes.
Declaration of Independence, when they were just a bunch of states uniting. But then just as soon
These
as
states
Articles-
united.
Well, as soon as Article 1, as soon as the Articles of Confederation came to be, Article 1 gives the proper name for it, and it's
The United States of America.
at that point.
Right.
At that point, it was properly uppercase U.
But right, but
Yeah, I'm
after
just
that-
clarifying.
One,
that
way-
because
one way it's a
United-
verb. One way it's being used as a verb.
Yeah.
The other way it's being used as a noun.
As a noun, yeah.
That's the
And
proper
in that
name.
way, it's a noun. So.
Right.
The United States there is the United States under the martial law rules. Like it's the corporation of the United States,
Yeah, that's federal jurisdiction.
which is why they don't have jurisdiction
Right.
over a man.
Right. This is 18 U.S.C. 241. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of his having so exercised the same, they shall be fined under this title or imprisoned not more than 10 years or both. So again, you have to use their words. Okay?
Yeah.
So you always say that they conspired to injure, oppress, threaten, and intimidate me. You see what I'm saying? In the free exercise of my right. And
Are you referring to who's the two people on a traffic stop, or you just? Did you just
well,
throw
when
that
it goes to court, then the judge is conspiring,
I see.
and prosecutor's
I
conspiring.
see, gotcha.
Judges have bought and paid for a clerk masquerading as
Actually,
a
the
judge.
minute they radio,
Yeah, right. There's people he's talking to on the radio.
right,
Absolutely.
Conspiracy.
Not just him.
wire.
Well, that could be brought in too.
Yeah. Yeah.
They're passing false information over.
Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant to any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the constitutional laws of the United States shall be fined or imprisoned not more than a year.
Interesting, they use your word inhabitant.
That's right.
Interesting.
Yeah. Free inhabitants, right? Articles of Confederation. Whoever, in any of the circumstances referred to in section B, okay, intentionally obstructs by force or threat of force, including threat of force against religious real property, any person in the enjoyment of that person's free exercise of religious beliefs. And there's a guy that I know that regularly opens bank accounts by saying, without a social security number, by saying that I have a religious objection to that. Anyways, that's carried on the jurisdiction conference call. I don't know if anybody listens to that at all. The Republic of Texas has a jurisdiction conference call where they get letters from the IRS saying they don't have jurisdiction. And so then from the tax court, I should say, from the tax court saying they don't have jurisdiction. If the tax court doesn't have jurisdiction, then neither does the IRS.
Yeah, because it's two different entities.
Well, the IRS is subordinate to the tax court. They have to do what the tax court tells them. Anyways. And so, 2707, 18 U.S.C. 2707, a good faith reliance on a court warrant or order, a grand jury subpoena, a legislative. See, this is where they get the good faith defense. Okay? And you have to defeat this. But if you're ready to defeat it, you can. Anyways, a good faith reliance on a court warrant or order, a grand jury subpoena, a legislative authorization, or a statutory authorization, including a request of a governmental entity under Section 2703F of this title, a request of an investigative or law enforcement officer under Section 2518.7 of this title, or a good faith determination that Section 2511.3 of this title is permitted the conduct complained of, is a complete defense to any civil or criminal action brought under this chapter or any other law. And so you know that Comey and Clinton and all of these criminals, that's why they're taking so long putting these cases together, because they can claim good faith.
They can claim good faith.
Of course.
They were doing it for the good of the country, and because their boss would
Even lying.
or whatever.
Yeah, that's right.
Murder.
Make it up.
Yeah.
So how do you defeat that?
Well,
You get them on intent.
you have
That's where
to.
the crime exists.
You have to. Well, you have to know what all these sections are all about. Number one, and a court warrant or order, a grand jury subpoena, legislative authorization. You have to know what potential legislative authorizations they might be operating under. You see what I'm saying? Or a statutory authorization. I mean, that's a whole can of worms. So you know that's what they're doing. And that's why Barr is taking his time building his case. Because that's exactly where they're going to say, well, we're just offering a good thing.
So they're looking for the bad intent.
That's
That's
because-
where the crime is proven.
That's right. No evidence obtained by an officer or other person in violation of any provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States of America. Notice how here they spell it United States of
They did.
America.
But we all know that the Constitution of the United States of America is actually the Constitution of the United States.
Well, that's true. And this is the Constitution and not the Articles of Confederation.
Which is the Constitution of the United States of America.
And, and Texas joined the Confederacy.
That's why that's more proof of what you said.
Yeah, exactly.
Because they
Exactly.
wrote out the laws of the United States. of
Texas
America.
joined the Confederacy and the Union.
Yeah, I would disagree because the United States of America is what exactly?
That's the federal government under the Constitution,
Which is run by whom?
the Roman cult.
Okay, so therefore, it has nothing to do, I don't know so, well then if United States of America is in the Constitution with the small "the" in front of it, then that was basically their control mechanism.
Of course.
Well,
Matter of fact, it's owned and operated by the crown and then the Roman cult.
I would agree.
oh, okay. This is a bit of a quandary in that this is why I'm always saying that THE is the proper spelling is given in Article 1 of the Articles of Confederation.
That's why it's not
They're
talking
all-
about the Articles of Confederation.
Okay.
Correct.
Okay, well, what are we talking about when we're looking at 28 U.S.C. 1746, 1 and 2? How is that
Well,
spelled?
that's the same thing.
Well, the problem is, though, they're trying to say that it's two different places at 28
Okay.
U.S.C. 1746, 1 and 2. That's why they're giving 2. Two is under the United, is definitely within
1746, 1 and 2.
Yeah,
Yeah.
felony perjury statement.
Well, it's talking about,
That's their-
it's talking, in my opinion, it's talking about the District of Columbia versus one of the states.
Well, it's talking about being on federal territory or not being on federal
Right,
territory.
exactly.
Just as I'm saying, there's federal territory in each one of the states.
Yeah, but that's
Or
a
the
federal enclave is what it is.
Well, it would still be the United States.
I
is the-
agree.
That is the United States. So, 28 U.S.C. 1746, 1 and 2 is talking about territorially, and they mention the laws. So it's both territorially, or on the land, or the government. It mentions two different ones. Two
Right.
basically puts you in the United States under the laws of the United States, and one puts you in the United States or on land of the United States.
That's
or
why
land
I
under
always
the
put-
laws of the United States.
That's why I always put without the United States.
That's what I always do. Well, I always put in 28 U.S.C-1, and sometimes I'll put right out without the United
I
States.
still put without the United States. I'll put
Okay.
28 U.S.C. 1746 1, and then I'll say without the United States.
Well, that's how I
say
did it on my
it's-
passport.
That's redundant.
Yeah, that ensures that there's no
Right.
confusion.
Confusion.
No confusion. But the problem is, like I'm saying, going back to this little conversation here, even there in 28 U.S.C. 1746-1, it's spelled with a lowercase t. So
Right.
what are we talking about?
Well,
here?
my question is the word land used in that statute?
All of those statutes, you have to understand, are for the
In fact,
the corporation that was set up in
Right.
well, the Constitution, not the Articles of Confederation. None of those statutes apply to the Articles of
right, the
Confederation.
Articles of Confederation is our defense as a man.
I agree.
Forget the Constitution.
Yeah, no joke.
Oh, absolutely.
I agree.
I did.
Take a,
That's why when everybody's talking about, the Constitution, it drives me crazy. I'm saying the Constitution only applies in the United States.
Right.
Are you in the United States?
Right.
Well, if you're a U.S. citizen, well, they don't know the difference.
Parts
so
of it
it's-
apply.
It's
Parts
all
of,
crazy. So,
parts of it apply, or may apply. Actually, maybe not, because it says no state shall accept anything but gold or silver coin in a payment of a debt. But the United States has territories that are called states, so it could be just those ones. You know what I mean?
the insular state.
well, that's sort of like just that right there is just how a man can ironically turn the thing around on them, because those states are probably that aren't supposed to do that with the money are probably just the federal states.
Yeah.
And
Yeah,
not
I agree.
just like the rule with NSCA, how that law was passed by Congress or congressional
Right,
mandate.
Clean
but-
Water Act.
But technically, it only applies in the United States. It has nothing to do with the United States of America. But yet we can turn around.
But
and
the
tell
United
the judges-
States still has jurisdiction over water. I mean, once you go off the coast, then that's clearly admiralty.
Right, that's where
Yeah, but-
that's
but
where
to-
the
but to
British,
start claiming that you
they
can
claimed it right from the beginning, the
Right.
waters.
Right.
But
And
if you
we
start
agree-
claiming people's ponds and streams,
Well,
now their
yeah, that's
property,
getting
I-
excessive.
we're getting
Yeah,
crazy.
I know.
But they have a point. If they have a point.
Yeah, well, they
But
may
it has to
be
be
they may be
navigable,
getting the
doesn't it?
point of a rifle.
Does that have to be navigable for them to have jurisdiction?
We have to look
You're
at
Navigable
saying all the
waterways?
water even goes into into a little stream going across your property.
What about the
That could-
underground streams? That too?
I guess.
I mean,
it's water.
Where does it
isn't
end?
It's water, isn't it? Yeah. How about the big Ogalla aquifer under almost the entire Midwest? Does that mean that the land above it is theirs too? I mean, come on. He's getting a little nuts, but that's what brings about revolutions.
Nigel Farage has offered Trump a election for Boris Johnson, a Brexit election alliance?
Well, he offered him that months ago, but the question of the election was still in the air. They've now declared,
Yes.
they've now said
Right.
there's going to be an election, and Nigel Farage does not want this new treaty to be a part of the Conservative Party manifesto, as they use, because it's a treaty. It still keeps the UK in the EU, all bar name.
Right.
It's called the Brexit, but it's not.
Oh,
It
okay.
still keeps them in alliance. So Nigel Farage wants to have a discussion, I think, with Boris Johnson to say, okay, we'll fight this election, you win, and you take us out on a no-deal WTO terms. So it is a complete Brexit.
Right.
And then there's no jurisdiction by the European Court of Justice. There's no, what do they call it? No common market compliances.
Right.
We get our fisheries back, we get our laws back, we get our sovereignty back as Britain. And that's the way he wants to fight it. Because everything else is either remain
It's strings.
or you stay attached to the European Union and they still control, but then at this point it's worse because Britain has no veto. They can't say anything.
Right.
And if they do, they say, okay, well, we'll go to court.
Yeah,
And they've
right.
done that in
Go
the
to
past.
our court.
Exactly, our court, the European Court of Justice.
Yeah.
And they've done that before, they've lost every time.
Yeah, no doubt. Yeah.
So, yeah, I was watching Nigel Farage last night, and actually he broadcast an interview that he had with President Trump. They were talking on the phone.
Right, I heard it.
Yeah, it was.
So it sounds to me like they're getting their act together, right, or am I wrong? The risk is lessened that it's going to be bad if they've improved their odds, the way they're approaching it.
Well, it's the deep state, but the thing, it's a global. So once Britain leaves the EU is toast, it's gone.
Yeah.
Because Britain is financing, along with America.
Well, they're already fighting over the finances too.
Yeah, of course they are. Because the no deal is, you want 39 billion, go swim. And by the time another 2 years has gone, because if they go through with this deal, this new treaty, it's not actually Brexit. They're now going to have to spend another 2 years minimum to go through a free
Right,
trade
kicking
agreement.
the can down the road.
Well, they're not really kicking it, they're just rewording it to keep us in Europe and then actually give us less power as Britain, as England and so on. So it needs to be a complete
Which
break.
I would think that the people of Britain are starting to wake up a bit.
You would think, but
Yeah,
where's the
you would
demonstrations?
Yeah, I mean, there are an awful lot of pissed off people. I mean, I've left comments, and it amazes me that the same thing doesn't happen over here in America, because you've still got, a percentage of Democrats who are literally Democrats to the death. And it seems you've got the same thing over there with Remainers. You talk about Remainers and Brexiteers and so on, and your Leavers want to leave. And they've got the Remainers that are talking about, well, we didn't know what we were talking about when you did the referendum. You didn't explain what leave was. Leave meant leave.
No joke.
It didn't mean leave with an attachment to this, an attachment to that, and a deal. It meant leave, and let's sort it out later. That's what it meant. And it's been going on for 3 years now.
You'd think the people would be getting upset about it.
Yeah, I mean, they are getting upset, but there's a backlash against the political class, because it's now come to the stage where it's very definitely Parliament against the people. The people voted in this referendum to leave Europe.
How many times do we have to vote?
Yeah,
That
really.
would be the
Well,
question.
I mean, one of the parties wants to just get rid of Article 50 and stay in. The other one, the Labour Party, what they want to do is they want a second referendum. They're going to go to Europe, plead for a second referendum, so they need to extend Article 50 further. Then they're going to campaign against it so that they can stay in the European Union.
Right.
Which everybody's going, what? You know, you fight for a referendum, and then you fight against that referendum to stay in the European Union. And then, of course, the Conservatives, now they're trying to fight to get Brexit, but it's not. It's a treaty that keeps us in Europe.
So
And then the Brexit party with Nigel Farage is just, fuck it, we're done. You know, shut the door, that's it. You're not getting a penny off us. Our waters are ours. You send any trawlers in, we'll fucking sink them. That's what he's talking about. And that's what needs to be done. That is Brexit. And that's what the people are suggesting. And I have said, and I've quoted, I've sent comments, listen, never mind this deal behind the doors, Nigel. Get this, fight every seat as a Brexit seat. And the chances are the Brexit party will win the majority and become the government in the UK.
Right. That would be great.
And it will smash smash all parties. My concern, and I guess his concern, is that there are people that, I'm a Conservative for life, I'm not going to vote for anybody else, or I'm a Labour,
Right.
I'm never going to vote for anybody else.
Yeah,
And that's the problem. You've got the same shit over here. I'm a Republican. No, I'm a Democrat.
Right.
And they won't do anything different. They've got the divisions set in all of the countries.
Right. Yeah. Well, in America, over 50%, I think, are almost now just independent or not affiliated.
There's more people that are not registered voters in the US now than there are registered voters.
Right.
So, are they independents, or if they just don't give a shit anymore? I don't care. You know, you vote. Fuck you. I don't care. I'm not part of the system.
Exactly.
I don't give a shit anymore.
I hope that's what it is.
Yeah, well,
I
the
don't
problem
think
is that, I mean, it's the same thing over in the UK.
I'm fed up, but not realizing they want to be out of that system. I think it's just I don't want to participate for other reasons, right? It's not
Well,
that.
the problem is they don't want to be a part of that bullshit that's
Yeah.
going on. What they don't realise and they don't understand is that they don't know how to be outside that system. So whatever happens anywhere else, they're still part of it and they're still roped into it.
Yeah.
So they can make the decision not to vote, but it doesn't matter. They're still going to be affected by it.
Most people don't realize, Americans have been brought up to, voting is such a sanctified act, you don't vote, that means you can't complain. Say, no. See, that's the way you've been taught.
Mm-hmm.
If we're in Vegas, and you've got $100 in your pocket, and I've got 100 in mine, we walk by a gambling joint, you go in and gamble and lose it all, you can't come running out here to me and tell me that you want me to help you pay the debt because you went in there and gambled. I didn't, so I have nothing to do with it. Same thing with, now what can be any more in a gamble than to gamble on someone saying they're going to do what they say they're going to do? That's human nature. That's the biggest gamble of all. So if you participate, the whole political thing is a gamble.
Yeah.
First, you gamble first of all if your your man's going to win, and then you're gambling on whether if he gets in, if he's going to do what he says he can. So I'm not part of the whole gambling system, so I wipe my hands on it.
Right.
You have to live with whatever happens if that guy gets in office or doesn't get in office. You got to go with it. I'm outside of it, so I got nothing to do with it. That's the way I look at it. That's the way we're not taught to look at it.
That's what we should be looking at, is that we are a republic. I'm not talking legal here, but my individual rights supersede everything else.
Absolutely.
So you can vote for whoever you want, but don't turn around and tell me that my vote, because I didn't vote, I don't count. No, it's the other way around. You voted. You are the one that has to live with the consequences of
Absolutely.
being a part of that system.
Right.
I didn't vote. I'm part of the republic.
Right.
You go fuck yourself.
That, I actually like your explanation is
There you
better
go.
than mine. Like, basically, it's the same thing. That's the way
Yeah,
I look
that
at
is
it.
good. Yeah, they bought in.
Yeah. You gambled, you have to live with the
And it's
consequences.
the contract, right?
I'm not in it.
They
So leave
signed
me
up.
out of it.
Okay, so no evidence obtained by an officer or other person in violation of the provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States of America shall be admitted in evidence against the accused on the trial in any criminal case. And it is an exception to the provisions of subsection A of this article that the evidence was obtained by a law enforcement officer acting in objective, good faith reliance upon a warrant issued by a neutral magistrate based on probable cause. Yeah, right. And so this is, again, the good faith. Government officials are required to know the law. Government officials are required to know that a warrant may not be issued. A capias may only be issued after they get jurisdiction and hold a trial and a conviction. Any denials of due process are bad behavior, and they always deny due process in countless ways. That's why I recommend that you have one of my kangaroo court survival laminated sheets with you in their so-called court.
So is violation of due process a federal crime?
No.
After they've been noticed.
It's
because they like to hide behind that and say, fine, in order to object to my lack of giving you due process, you have to get involved in more of our process.
Well, again, you got to stick to your guns and point out that they deny and then file judicial complaints. Now, in New Jersey, that may not be that easy. I know in Texas, it's a lot easier, and that's what I file. I file judicial complaints, and
yeah. But so my question is, if they're doing it in understate, I want to take just there's that saying, don't make a federal case out of it.
In a way, they're violating their oath of office.
well, they are.
Yeah,
Right.
That's true.
Right, so that's the criminal complaint. And that's where I am right now
Yeah.
with I mean, I have 20 official misconduct criminal charges, which is a minimum of 1 year in jail.
Right.
No plea bargaining.
Right. So I would be filing criminal complaints.
That's where we're heading. We're just getting all the evidence, like you say. You have
Well,
to get the
I would
evidence.
go ahead and, I mean, you can't wait because you're never going to have all the evidence.
No, enough to, well, when I say all the evidence, it's because it's a chain conspiracy. They've all been involved in
Right.
20 or 30 public servants.
Yeah. Well, again, I would file a criminal complaint with what I have, and then you can always file another one and add to it. You see what I'm saying?
Yes.
And that kind of thing.
Yeah,
So when does a criminal complaint, when do you take the step from criminal complaint to lawsuit?
Sorry?
When do you take that step from criminal complaint
The
to
lawsuit?
lawsuit?
Well, it's up to you when you take it to there, but you can attach a criminal complaint to a lawsuit. You see what I'm saying? And
Just as further evidence.
yeah, as evidence. That's right. But what I do is if I'm going to make a criminal complaint, I serve it on people like the criminal district attorney and maybe the U.S. attorney. And then if I file a lawsuit, I'll file a lawsuit against them too for failing to prosecute. You see what I'm saying? And watch them squirm on that one.
No.
And what?
I'm just wondering if that's not a criminal act.
What?
Failure to prosecute.
Exactly it is. But you sue them, and what I'll do sometimes is I'll make another criminal complaint and add them as accomplices after the fact because they're failing to prosecute. And I know for a fact that I did this with, there used to be a district attorney in Tarrant County, and well, he's not there. And he wasn't there shortly after I filed my criminal complaints. And he wasn't there after that. And they'll never tell you that it's because of what you did, but it's amazing how many times I do that stuff, and all of a sudden maybe it's just something as simple as they don't run for re-election.
So
you
this
know?
is your cattle prod, really. Your criminal complaint is your cattle prod, right? You're
Yeah,
just moving it along
right.
in their system.
Right.
You're having them
Right.
address it.
Right.
Okay.
Right. Yeah, because they're not all crooks, okay? And some of them, many of them, if they're not doing the right thing, maybe it's because they just don't know.
I would
And
say that's probably
so
the
it could
majority.
be part of their educational process too.
Yeah.
And so again, but if you don't complain, you know, the Nazis said in the war crimes trials that nobody complained, right? So you got to complain.
Yeah.
And the important thing is to bring up the right issues and have evidence to support it. You see what I'm saying? And Judicial power of the United States shall be vested in one Supreme Court. This is bad behavior, right? And in inferior courts of the Congress may from time to time ordain and establish the judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive further services of compensation which shall not be diminished during their continuance in office. So again, they only hold office during good behavior. So if they're denying you due process, that's bad behavior. So then, you know, what I always do is I put it in writing and I file it into the court, okay? Because if you do it when you're in there, sometimes they'll threaten you with contempt or something like that. You see what I'm saying? So I file it into the case. And I'll tell them, you're in bad behavior. This is not a court. When they're not in good behavior, that's not a court then.
Right.
You see what I'm saying? And then, when they're not in good behavior, if it's not a court, then...
So them threatening contempt.
Impersonating a public servant, okay? If they're not in good behavior and it's not a court, then, and he purports to exercise the function of a public servant or public office, has no lawful existence under the Constitution of this state or of the United States, okay? So then if it's not a court, you see what I'm saying?
Mm-hmm.
He's in bad behavior, it falls into here, impersonating a public servant.
And our mental, we've been trained for 50 years to think a certain way, and it's so difficult not to honor the judge and that whole system.
Yeah, but they're just a bunch of crooks. They're bought and paid for.
I'm right now, I mean, I'm literally...
And and that's what you put, that's the kind of stuff you put in the misconduct.
Oh, no, yeah.
You see what I'm saying? Misconduct. In my judicial complaints, I put that stuff in there. He's in bad behavior. He's denying due
Right.
process.
I have a judge right now who's threatening to put me in jail for 30 days. That was the judgment. And when I put in my austerity and challenged the jurisdiction, he went through with the sham, even though it had Glenn's take one more step as far as jurisdiction. And the people who want me put in jail for trespassing continue to bother him. He's now sent me a fourth letter trying to get me to agree, but he can't tell them he's not going to do anything.
I would again, the Postal Inspection Service, file a complaint for mail fraud with the Postal Inspection Service.
Well, that can always be done after the fact.
Yeah, whatever.
I'm just waiting to see November 13th. I'm going to enter the premises for our annual meeting where we are allowed to vote. I'm a member, which is I have property rights, and they're saying they've trespassed me from the property, and so now it's basically showdown. We're going to find out. Are they going to?
I would file that complaint, that misconduct complaint, and the issue is he's in bad behavior, and it's not a court.
Right.
He's impersonating a public servant.
Well, he's not going to. I don't think he's going to do it. I could always do that after the fact.
Whatever. Okay, so you know what you're doing. Anyways,
You just have to be
this
careful
is
you're
my
not doing it
laminated.
from jail, Nelson.
This.
Pardon me?
You just have to be careful you're not doing it from jail. That's the
Well,
problem.
it's impossible to do from jail.
That's fine. I'm willing to spend the 30 days. That's no worries.
Okay.
Because then they're responsible, and I put them on notice that they have to pay me if they do it. Meaning the
Well, yeah,
church,
that's
not
another
the
story.
court.
Good luck with
Yeah.
that. But anyways, this is my laminated sheet. One side of it. Bad behavior is fraud upon the court. Fraud upon the court is fraud which is directed to the judicial machinery itself and is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted. It's called fraud upon the court. And this is the backside of that. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Once challenged, jurisdiction cannot be assumed, it must be proved to exist. There is no discretion to ignore that lack of jurisdiction. Where jurisdiction is contested, the burden of establishing it rests upon the plaintiff.
So as soon as the judge says, I'm going to enter a plea for you, he's in bad behavior.
Yes, well, you got to tell them that, no, you're not. I don't agree. If he does it anyways, then he's definitely in bad behavior.
Right, that's what my guy did. He went ahead anyway after he read your stuff, those two that were right there. But he couldn't, to save face, he's never, I don't think, ever had that happen in his court.
Well,
So he doesn't know the
he
implications.
probably never had somebody file a complaint either for misconduct.
Right.
The burden of proving jurisdiction rests upon the party asserting it. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. In other words, that you're a U.S. citizen. However late this objection to jurisdiction has been made or may be made in any case in an inferior appellate court of the United States, it must be considered and decided before any court can move one step further in the cause,
That was my
as
favorite.
any movement is necessarily the exercise of jurisdiction. And that's a U.S. Supreme Court case.
There are actually 7 elements of jurisdiction as well.
That's right. I have those. I wanted to make
That
a
would be helpful to have.
I wanted to make a video on that. That's one I'm working on.
I already did that with a friend of mine.
Uh-huh.
Well, it wasn't video, it was more of a
7
podcast.
elements, 7 elements of jurisdiction.
There's 7 elements of jurisdiction, and they have to prove all 7 elements.
Wow.
Wow, I thought there was only 3 jurisdictions. 7.
Jurisdictions are elements of jurisdiction, right? That's different, right?
Seven elements of jurisdiction.
Well, they're still talking about 7 types of jurisdiction. I'm only aware of 3.
Well, that's
Personal,
not
political.
types. It's not. That's a type of jurisdiction and an element of jurisdiction is two different
Yeah,
things.
those elements will be in every one of
There's
those.
impersonating jurisdiction. There's in rem jurisdiction, and I'm not sure what the other one you're talking about is. But there's 3 sounds about right. But the elements is what they need to prove to show that they have jurisdiction.
See, that's one of the things that people don't realize. They start going into court and raising jurisdiction, and okay, they have to prove all 7 elements, but the people who are saying, well, you don't have jurisdiction, prove to me you've got jurisdiction. I mean, they don't even know what the elements of the jurisdiction are that the court has to prove,
Right.
or
Right.
anybody else for that matter.
Well,
So,
my understanding is
They could
that
say bubblegum. For all you know, right?
if you can say, okay, well, this element, this element, this element, where's the proof? I want the documented proof. And
Yeah,
they-
do you have
they
that
will-
that you could?
I have it on my
You
computer
can share.
upstairs.
okay, I mean, the way my understanding is there's 3 main types of jurisdiction: the territorial, the personal or political, and the subject matter.
Right.
For territorial, they have to prove
But
in
that's
here.
that's
you-
nothing to do with the elements.
Okay,
Well, the elements
I'm
would
I can't remember what they all are, to be honest.
they would
But I
apply to
recall-
all 3 of those types.
okay, so
Those,
there's
those
7
elements
yes.
are within
Yes.
every
Right.
one of those types.
Yes.
Yes, that's just
Yes.
components of it.
Right.
Okay,
The
all right.
components of the.
Okay,
Right.
well, that's something I'm missing then. I
And they'll
need
all
to
be
know
different.
that.
Yeah.
I
Yeah,
didn't
I
know
need to
that
do a video on that.
I
I've
didn't know
got
there were
that.
elements to them. I just thought that if I challenged territorial jurisdiction, prove that this was on land that is owned by the United States.
So that's what he said. You don't even know what the elements are.
Well, that's true.
Right.
I thought that was the only element. They got to prove that they're on.
No.
That it was on United States.
The
What
bar, the
other
bar is
things?
even higher than that.
I don't have that stuff in front of me.
Or
I can't
or
remember
for
what it was,
political.
because it was like 18 months or more when
Or
I
for
actually
political,
did it, so I
personal
can't
political
remember.
jurisdiction, they have to prove that I'm a U.S. citizen.
Well, not too.
Which they'd have to prove that I either took the contract for Social Security, knowingly, willingly, intentionally, with full disclosure, or they have to prove that I stood in front of an INS agent and took the oath of office, which is the sole at 8 USC 1421. And what other ways can you be born? You can be born a U.S. citizen, which is horseshit. I wasn't born.
You're born a state citizen.
Well, you're actually probably born a free inhabitant, and you get to choose to be a
Yeah,
state
I guess.
citizen later on. But
Yeah, exactly.
so I need to know. I need to know about these 7 elements. This is
Yeah.
something I don't.
It's on my laptop.
Okay, I'm
upstairs.
definitely got to get it together with you.
I've got that, and I need to do a video on that. Maybe I'll have one before I finish this. I'll have it to present, but we'll see. Depends on how much time I have. I doubt it. But anyways, a court has no jurisdiction to determine its own jurisdiction. For a basic issue in any case before a tribunal is its power to act, and a court must have the authority to decide that question in the first instance. A departure by a court from those recognized and established requirements of law, however, close apparent adherence to mere form and methods of procedure, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. The burden shifts to the court to prove jurisdiction.
Actually, we have to be careful with that, because when you're actually disputing jurisdiction, you're not disputing necessarily the jurisdiction of the court itself. You have to dispute the prosecutor's jurisdiction to file a case against you.
Right, he's the one claiming jurisdiction,
Yes,
but
the
in these
court then can make a ruling on that jurisdiction.
in these traffic courts, the judge is bought and paid for. It's an administrative court, so you're still challenging the court's jurisdiction.
Yeah, but I mean, again, we have to be careful.
They're working together.
Yeah.
Yeah, but it is the prosecutor that usually tells the judge to push the case forward. So he's actually the one who's coming after you. That's who you should go for.
Yeah, that's right. That's
The
it.
challenge-
Query,
the-
challenge
He's the one that you
The
should go for
prosecutor's
initially.
jurisdiction.
He's the one, basically, the judge is working for the prosecutor.
Yeah.
You know, the
He's
prosecutor
not, impartial.
Well, the prosecutor's the one that says, yeah, let's go get at this guy.
Right, right.
But he's basically telling the judge what to do. And in a way, he is a third-party debt collector, as we're getting to, because there's no such thing as a state-issued license to practice law. It's a private club. So there is actually two entities there working against, coming after you. Though supposedly he's an officer of the court. He did take an oath to be an officer of the court, but still, he didn't get a license to do that from the state. It's a bar membership. I mean, that's the way I see it. I mean, does that make any sense?
No, it's true. You're
No,
right.
wait,
There is
sir.
a state-
It's a bar membership, you're right, but
Yeah.
a license, there's two kinds of licenses.
Okay.
There's express licenses and implied.
Well,
And an implied license is one, like when you pay a filing fee. And I could show you a court case that talks about it, okay? So,
But I'm talking about a state-issued license to practice law where he goes down and applies for it and signs for it and they issue him a certificate.
But they would never. They would never do that.
Of course, well, because there's not one. There's no state-issued
Right.
license to
So
practice
anytime
law.
that a prosecutor is there
it's-
representing
but
the
that's-
state,
That's an implied license.
He would need-
because they let him practice law.
Well, you could still ask
Yeah.
them though. They should be.
Really?
But what they're saying, what they give to the general public is that there's an actual license that is issued. That's what.
Well,
it's
no,
believed. That's what's
there's two
believed.
kinds of licenses. There's express licenses and implied.
Well, are they
Express one's on a piece of paper. Implied is implied because of the actions of the person having the right to give it.
I don't think the public is going to appreciate. The public has been led on to believe that there's not an implied one, but an actual one.
listen,
Well,
we're
well,
here
the
conscious
The
of what
public
we're
is led
trying
to
to
lead a
do.
lot of stuff, and they're a bunch of brain dead idiots.
That's true, but as the public, you can ask them where is your actual license, because that's what there was been. You can ask the prosecutor, you have
Well,
a license, as well
Okay, we
as
gotta keep.
is he registered to act as a foreign agent?
Let's keep moving here.
Within the
Yes,
state?
you're right.
He's supposed to register
yeah.
for that as well.
That's
As
true.
well, he's acting as power of attorney for a corporation, which is the state. Where is his letter to act as
Okay,
a...
did you want to do your presentation?
No. I'm sorry.
The fact that the petitioner was released on a promise to appear before a magistrate for an arraignment, the fact that that fact is circumstance to be considered in determining whether in the first instance there was probable cause for the arrest. So that's what, if they were neutral and unbiased, that's what they should be doing. But how many times do they do it? Rarely. It is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as voluntary subscription to a license. All jurisdictional facts supporting the claim that supposed jurisdiction exists must appear on the record of the court. When liberty and freedom are at stake, your silence isn't golden, it's yellow. Where a court failed to observe safeguards that amounts to denial of due process, the court is deprived of juris. Not every action by any judge is an exercise of his judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law judge loses subject matter jurisdiction, and the judge's orders are void and no legal force or effect. If a court, this is Federal Rules of Civil Procedure, 12H3, if a court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Defense of lack of jurisdiction over the subject matter may be raised at any time, even on appeal. Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. It's a void judgment. The county attorney, and this is in Texas. Now, I don't know if it's in other states, but this is like really powerful, because the county attorney shall represent the state in all cases in the district and inferior courts in their respective counties. So, if you get a traffic ticket, it's always a city prosecutor. It's not the county attorney. You can actually, I've actually brought that up for them, and they don't want to talk about it. And what a friend of mine suggests is we should call a county sheriff and have him arrested for impersonating a public servant, because they're not a county attorney. See what I'm saying? And then what happens when they don't have probable cause? Although probable cause may be inferred from malice, although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. So when they don't have probable cause, it's a malicious prosecution. So if it's not a crime, it's a malicious prosecution. If there's no indictment, I can't tell you how many indictments I've seen that are fake. Okay? If it's not a proper indictment, it's a malicious prosecution. A universal principle as old as the law is that a proceeding of a court without jurisdiction are a nullity, and its judgments therein without effect either on person or property. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. A court cannot confer jurisdiction where none existed, and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. Where there is no jurisdiction, there is no judge. The proceeding is as nothing, such has been the law from the days of Marshal Saya. Now this is actually a federal court case, right here, Manning versus Ketchum. That's a federal court case, but they're citing a Supreme Court case, Bradley versus Fisher. That's U.S. Supreme Court, and that case is citing Coke, which is in the 1500s. So this is as old as time itself. Brutum Fulman. I filed a lawsuit in state court in Texas. Brutum Fulman is an empty noise, an empty threat, a judgment void upon its face, which is in legal effect no judgment of all, by which no rights are divested, and from which none can be obtained, and neither binds nor bars anyone. And I filed a lawsuit in state court against FedEx, and FedEx removed it into federal court, and I didn't want it in federal court, and so I told the judge, I said, I have nothing but contempt for your court. You have an inferior court of limited jurisdiction, and I demand everything you do is Brutum Fulman, and I demand that it be removed back into state court. And I've never had a judge be so nice to me. He was so nice, I couldn't believe it. I felt guilty afterwards. He wouldn't dismiss it, and ultimately he did dismiss it. But when he did dismiss it, he said that I called all his judgments Brutum Fulman.
Wow.
Anyways. An officer who acts in violation of the Constitution ceases to represent the government. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. Okay, so they're not representing, when they're in bad behavior, they're not representing the government. It's not a court. You see what I'm saying? In arriving at our decision in this matter, we do not depart in any way from our holding in Hemling versus Jensen that the doctrine of judicial immunities extends to courts of limited jurisdiction. But when a minor magistrate acts wholly without jurisdiction, civil liability attaches for his malicious and corrupt abusive process and his willful and malicious oppression of any person under the pretense of acting in his official capacity. And so that's, I don't know, that's just could be a state court or federal, I'm not sure. Texas Penal Code is impersonating a public servant. And we already went over this, so we'll go over it again. A person commits an offense if he impersonates a public servant with intent to induce another to submit to his pretended official authority, to rely on his pretended official acts, or knowingly purports to exercise any function of a public servant or public office, including that of a judge in court, and the position or office through which he purports to exercise a function of a public servant or public office has no lawful existence under the constitutional laws of the state, of this state or of the United States. And so, when that judge is denying due process, he loses subject matter jurisdiction. He's required to dismiss that case. And if he doesn't, then again, he loses subject matter jurisdiction. It's not a court. He's impersonating a public servant. Change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change we seek. So subject matter jurisdiction, do not give them jurisdiction. Always make special appearance. Print out their denials. Point out their denials of due process. Do not allow them to enter a plea. It gives them jurisdiction. You're not entering a plea. I don't give you jurisdiction. And I was in jail one time. And this is the one time they took me to see a magistrate. And I told them it's a malicious, I started railing on them right off the bat. I told them this is a malicious prosecution. This is not a crime. You have, there's no probable cause of anything. And I demanded that they release me. And he didn't. But, and then he says, I guess I'll enter a plea. And I says, no, you're not. I don't give you permission. And he didn't. At the very end, when we were done, he said, well, you're going to have to come in and enter a plea. Come to court on some other date and enter a plea. So he didn't enter a plea. So anyways, you've already done, of course, one of the things I told him, is I said, I've been to the Supreme Court 5 times and you're next.
Question, why do we even have to make a special appearance if we're not?
Yeah, they're a bunch of pirates, that's why.
I mean, why even entertain them?
Sorry?
Why even make any special appearance?
Well, if you're going to go in there, you got to make it by special appearance. So they
If
presume.
we go in.
Yeah.
You're saying why go in at all?
Right.
Yeah, I agree. You've already demonstrated that you prejudged this matter as a bought and paid for a clerk for the prosecutor. So we are impersonating a judge today, are we? Demand that it be dismissed immediately. Those are all things that you could say. Again, when you're in there, there's the threat of him accusing you of contempt of court. And so I would file stuff into that before,
Right.
okay, and put it on the record, put it in writing. Then it's all appealable, and
You know what my statement is, or question is to that?
what
Starts threatening you with contempt of court.
is it, civil or criminal?
Correct.
Yeah.
What's that now?
Is it civil or criminal?
And he'll say civil.
Okay.
No, they
Well,
won't.
they can't. No, they won't say it. They won't
They
answer.
won't. They
won't
won't.
answer at all.
No.
They become used.
They-
Because
Yeah.
if they say it's civil, then the first thing the response to that is, where's the contract?
If it's criminal.
That I am in breach of.
And that's right. And they can't say it's criminal because it's not.
Where's the man who's making the complaint against me?
That's right.
It's a fictitious entity.
Contempt is it's probably always civil, actually. They just can't admit it.
What's that? You can only be in contempt of court on civil charges?
It's
No,
probably
the contempt
always.
of court, when they threaten you with contempt of court,
Oh, that's what
it's civil. You can say, well, is it civil or is it criminal? Because those are the only two types of offences
Right.
that you are going to commit.
Right.
Right.
And it can't be really criminal because you haven't damaged anybody
No problem.
and there's nobody. So it would have to be civil, and which means there's a contract. And at the point you say, okay, I'll do what you say, then
Just
they've
decide.
got the contract about contempt.
So yeah, where's a bona fide contract? So they can't say it's civil. They'll never say it's civil, because then the answer is, where's a bona fide contract?
Now you challenged his jurisdiction at that point on him levying contempt against you,
Right.
because you have to agree. If you agree, then there's the contract.
Right.
Contracts can happen at any time.
They will never admit that it's civil though, because that's the next natural response. In a civil matter, there's got to be a contract.
Couldn't you just walk into court and just ask that outright?
No, you got to wait till he threatens you with contempt.
Well, they might, if they know you're gonna do that, they'll just hold you in
They
contempt
won't.
and not even
Well, no, they can't do that. They gotta give you a chance.
do that.
With contempt, you can always beg forgiveness. Okay, that's equity, that's admiralty. You can always, oh gee, I'm so sorry.
Well, that's what they want you to do.
But
Well,
then by
yes,
saying
that's true.
that,
That's
by
true.
saying that,
But-
now you're in contract.
Well, that's
If you're begging, for
you're
forgiveness,
admitting-
are you not?
you're admitting the contract.
Yeah.
Yeah.
You're admitting the
Yeah.
contract. But the point is, though, is they just want you to do what they tell you, and they don't have any authority, and they're threatening you with contempt if you don't do it. And so then that's a perfect. Where is this civil or criminal contempt? Because they'll never tell you it's civil, because it's exposing their fraud. That's why they never say anything. Anyways,
So what happens when they don't say anything?
They'll move on to something
they'll
else.
move on to something else, of course.
Now, what you
Getting
will
them off.
find is the court bailiff by this point is approaching you at this point, usually.
Yeah,
That's
usually.
when you have to turn around to him and say, you fucking move away. Don't you touch me, I don't give you permission. Judge, get your man to stand away before he gets himself in trouble.
So anyways, the bottom line is that this American Elimination of Debt is a website where you can eliminate debt, and you can contact the guy at dbs81@yahoo.com, and you have to be proactive. You have to go on the attack. If there's something negative on your credit report, get it removed. They have never lost a case involving an unsecured debt. They've only had one case go to trial, and they won. And this letter that I'm about to show you, served on a third-party debt collector by certified mail 3 times with no response, can be used to get derogatory credit report information removed too. 3 times by certified mail, and if they don't respond, then you send it to the credit bureaus, and they have to remove it. This is the letter, and I can email you the letter if you want. Anyways, it says, Dear Richard J. Seister, Representative, I have not received adequate response of August 19, 2019 regarding my disputed card account number. Is specifically deficient in the following ways. You failed and refused to provide me with an explanation of the amount owed, what it is for, and how it was incurred. Number 2, you failed and refused to provide me with an explanation of how the amount you claim was calculated. Number 3, you failed and refused to provide me with any document that shows that I agreed to pay the amount claimed, either the original principal amount or the current amount. Number 4, you failed and refused to provide me with a copy of any executed contract showing my signature relating to the account you claim is mine, or the amounts you claim may be owed. Number 5, if you're a third-party debt collector, you failed and refused to provide me with evidence showing the amount you paid for this alleged debt. Number 6, you failed and refused to provide me with any verification or copy of any judgment that is or may be applicable to this dispute. Number 7, you failed and refused to identify the original creditor. Number 8, you have failed and refused to provide proof that a statute of limitations is not applicable to the account and or the monies claimed by you to be owed. Number 9, you failed and refused to provide proof that you are licensed to collect monies relating to overdue accounts, such as the one you claim in my state or in any other state of the United States. And number 10, you failed and refused to provide your applicable license numbers and the name and address of your registered agent for service in the state of Texas. As of the date of this letter, this is my formal demand that you provide the information cited forthwith above. Further, this letter is your formal notice that you're in violation of Texas and federal statutes relating to protection of consumers and collection matters. They include, but are not limited to, the following: the Texas Finance Code, Title 5, Chapter 392, Fair Debt Collection Practices Act, the Texas Deceptive Trade Practices and the Consumer Protection Act, and the Fair Credit Reporting Act. Oh, and here it is up close. I guess I could have read it closer. But the second page. Anyway, so there's probably up closer. There we go. Therefore, please consider this letter my notice for any required notice under any and all of the statutes cited above. If you do not provide the information required above in your next communication to me, or cease and desist in all collection efforts regarding the account in question, and remove any adverse information relating to such efforts and or the disputed account from my credit bureau files, I shall have no choice but to turn this matter over to an attorney licensed to practice in the state of Texas. In such event, you may become liable for fines and sanctions provided by statute, as well as attorney fees and costs required to prosecute the resulting action. If your offices are unable to provide the required documentation I have demanded, I will require at least 30 days from the date of any receipt of the materials to investigate the information. During such time, all collection activity that you must by you must cease. During this validation period, if any action is taken which could be construed as detrimental to my credit status, I will consult an attorney to consider legal action. If your office failed to respond in good faith to this request within 30 days from the date of the receipt, your receipt of this communication, all references to this account must be deleted and completely removed from my credit file, and any copy of such deletion must be sent to me immediately. Further, through this letter, I formally request you and your representatives do not contact me by telephone at my home or my place of employment. If your offices attempt such telephone communication with me, including but not limited to computer-generated calls and/or calls or correspondence sent to or with any third parties, I will consider such actions to be harassment and will instruct my attorney to proceed with legal action. All future communication with me must be in writing and sent to the address in this letter via United States Postal Service. This is an attempt to correct your records, and any information obtained by virtue of it shall be used for that purpose only. Sincerely yours, Nick. So anyways, that's the letter he gave me. And he said that he's won every case, and it doesn't go to court. They all just kind of go away and hide.
Now, there seems to be something that seems to be a follow-up,
What's that?
right? He's talking about in each one of those points, he seems to refer to something else that was already sent.
Yeah,
Well,
it seems to be a second
Yeah,
letter.
yeah, but that doesn't matter. I would just go ahead and send that letter just the way it is,
Yeah.
and let them respond. And you send it by certified mail 3 times. That's all you need to do.
Mhm.
And then if they don't respond, then send it to the credit bureau, the package. And they'll have to remove that off the credit bureau. Anyways,
I've got some debt validation letters myself, but similar to that, not identical to it. Problem is, you do get responses from them.
well, not for all that. They
No,
can't
not for
tell
all
you.
that. No, they don't. They don't
They can't
respond
tell you
to
what
the,
they paid.
No, no, they don't actually respond to the questions. What they normally do is ignore everything that you've just requested from them and continue with the bullshit.
Right.
But they still send you correspondence.
Right.
So they responded. So after they're out, well, we did respond to you.
You just
Yeah,
didn't
sure.
answer any of the
Exactly.
questions.
Exactly.
Yeah. So you have to keep. You just have to send it again. You know, here is the second.
Here's your second notice.
Yeah.
Here's your
You
third
failed
notice.
to answer any of the below listed questions.
Right.
Please provide.
Right. And the credit bureau is going to say, when they get that information, look, you did what you were supposed to. By sending them back
3 times.
even just the letter that they sent, because they're going to claim that it's up to the credit bureau to remove it, not
Yep.
to the other. So we don't
Yeah.
even care what the third-party creditors do.
Well, typically they're lawyers, or it will be a law firm, and they'll be
Right.
coming after you. And
Well-
they will file legal papers, small claims papers, and at this point you're challenging their jurisdiction. And this is exactly the
Well,
kind
but
of
they're
stuff
not
that
going
I
to take you
got.
to court because now you got proof that you asked all that stuff,
Exactly.
and
Yeah.
and they'll never take you to court.
Yeah, but the lawyers did that with Tara.
Did what?
They took her to court.
After filing that kind of stuff on them,
Yeah.
serving them.
Yeah.
Well, was it a secured loan or?
Well, no, it wasn't even a loan. It was the, I mentioned it before, it was the law firm or a law firm that was trying to recover insurance company costs.
Oh, there was no
for
version.
insurance.
Right. Yeah, that
So,
was.
slightly
Well, that's
different.
actually they had the property that they could claim or put a lien against, you know, if necessary. Or did she still own that property?
You know, it was foreclosed.
Oh, I see. Right. So they didn't have that. So they had nothing.
They had nothing.
Yeah. So they're wasting their time, really. They're fishing.
They were fishing, yeah. I mean, I just sent the stuff back and asked them all the relevant questions. And then we got the court notice and a postcard appear at this room number at the Superior Court, North Brunswick, or wherever it was, which we didn't bother going to. And then the next letter was to state, oh, you may have heard that there was a default judgment against you for our whatever case. I can't even remember the verbiage of it now. Please contact this office to arrange payment. So I sent that letter back with the red notice from mail fraud. Didn't hear a damn word after that, nothing.
Right.
Gone.
Right. Do we want to break for lunch?
Yeah, it's almost, well, it's 1:30.
Yeah.
Yeah, I'd say now's the time, because otherwise we'll go deep into the night again. We'll wait too much longer.
Article 4, Clause 3.
We found, yesterday Glenn and I met with, he was a friend of Glenn's, we met with a man who is kind of like-minded, and he's up in Tuckerton, so there's 3 of us now, kind of
In
in
this area.
South Jersey.
Right.
That's positive.
Yeah. Well, it's a networking thing, right? And there's probably lots more. You just need to, like all those people at that Birch Society. I mean, they're all like really close.
They are. Couple pieces of information and they're off to the races.
Yeah. 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 Exactly.
We went to a Birch Society meeting. I've never been to one.
What is it called?
John Birch, the John Birch Society.
Yeah.
They're conservative-minded people who have tried to become patriots and move us back to conservative values.
Right.
But they are actually basing a lot of it on the Constitution. And
Well, they do.
That's the fraud.
Well, but again, well, even
It's
under
a
the
fraud against the people.
Yeah, well, I don't know. And they're U.S. citizens and they're activists, is what they are. But it's still, they're very much active, and they're really close, and it's good to network with people like that for sure.
It's like they're prisoners banging on the
Yeah, that's
cell.
true.
Well, yeah, I mean, you have to be careful because they can certainly be charged with sedition and treason against the government.
No, I wouldn't say they could be. How
I
could they
agree.
be?
Because they're U.S. citizens.
Yep. Unless
They're
once
acting
you
against-
have, yeah.
Well, they're not. Sedition is military. It'd have to be armed.
I don't know.
Yeah.
Sedition, I'm not
Yeah,
sure
if you read
there's-
seditious conspiracy, it specifically says it's
Well,
got
it
to
would
be.
actually be treason, maybe.
Well, it's not treason because treason's a breach of trust of the Constitution, and they're in support of the Constitution. We just want the government to follow the Constitution.
I see. So they're just, it's kind of like the whole system is now. You don't really have any remedy because the ones that you're asking are in charge. You have to find the good people to do it.
Well, again, you got to create the political will,
Right.
right? In other words, you get enough people and educate them, and they start demonstrating and that kind of stuff.
Political will from the ballot box and all that other.
Right.
Whereas we as sovereigns, as free inhabitants,
We don't have to
we don't
participate.
need it. I discussed with myself the political will, and I agree.
Well, I think common law.
Yeah, we don't need the political will.
We don't need a political will.
How about common law
That's-
courts?
drag them in.
Well, and they would definitely participate in common law courts, and they would be of a like mind, agree with
They
almost
can't-
everything.
Yeah, but until they have to resign from the U.S., renounce the U.S. citizenship.
I don't think they do.
To be in a common law court,
Yeah, I don't think they do.
Well, they aren't actually.
Why can't they exist in, you know?
There aren't actually.
Parallel.
There is a common law. I mean, remember, the Articles of Confederation talks about common law.
yes, but
Oh, absolutely.
there's no de jure state to
Not the Articles, but the Northwest Ordinance.
Oh well, yeah.
Yeah, the Northwest Ordinance
There you
talks
go.
about it.
But does it refer to the common law in the states or in the territory?
Well, but if it's in the territories, then, because the territories ultimately became states, right? So if the common law was in the territories, then it's got to be in the states too. And if you read the state constitutions, it's there. Matter of fact, it says that the rights protected in the Northwest Ordinance are going to be forever. Even after the states are organized, in the territory. It says that they're going to organize 3 to 5 states in this territory, and the common law is going to be there. They're always going to be right to trial by jury, due process of law. I mean, let's get it out.
Yeah, I saw that. Yeah. But you know, I believe this is the way I feel about U.S. citizenship. All these people walking around out here that claim to be U.S. citizens, they really aren't. Because they weren't born on federal territory. They didn't go through the process mentioned in 8 U.S.C. 1421. And the contract that they signed for Social Security, they didn't do so with full disclosure. So all those 3 main points of entry into U.S. citizenship, none of them really did. So they're walking around saying they're U.S. citizens when they're not. There are Mexicans out here that immigrated from Mexico and went through the INS procedure that are more U.S. citizens than the people who say they are here. I mean, that's the craziness of it all.
You make a good point. Yeah, the people are.
And they would have, and the burden would be on them to prove differently.
Absolutely. But you got to know that those 3 points apply, which most people don't.
Right. So the presumption of U.S. citizenship gives the powers that be the right
To move forward with whatever they
well,
do.
It's not even a right. It
Well.
gives them the presumption.
Well,
And if there's no rebuttal, then they just railroad you.
well, that's why there's Sunday Mass at church for the masses. You take the masses and look at the wording, and you move the M from masses over to the, and it becomes them asses. And then you look at the dumbasses and see, move it around in your tongue and see how little it takes difference to make it from them asses to dumbasses. I mean, it's words are. That's just a little side.
You make a good point, John.
But it's not that we're dumbasses by, it was by design because they grabbed hold of the school system. That's what's so sad.
Right?
That gets back to 313 and 33. Schools, fools, and tools. I don't think you were here for that conversation.
I was in
We will use schools to make tools of willing fools. And it ties into numerology.
I'm just looking where it talked about common law, but I saw it somewhere else, and I'm wondering.
Well, you know, I believe that there was a type of U.S. citizenship even before the ordinance of 1787, because the point I made before was
Oh, here.
all the.
You have to be a U.S. citizen
Well,
to be
Well, all the people that went to the Continental Congress, though they were all state citizens of where they were coming from to represent in the Continental Congress, I believe that there was an oath that they basically had to take to the Confederacy because they were there, though they were there in the capacity to represent their individual republics. The republics were acting as a whole, so there had to have been some type of allegiance that they had to give to the Confederacy, even before the Confederacy was officially put in place with Article 1 or the Articles of Confederation. I believe there was. I believe there was some kind of oath that they had to take upon entering the Continental Congress even, from the very beginning.
Yeah, they had an oath of office.
Okay.
Here it is. Judicial proceedings according to the course of common law. No man shall be deprived of his liberty or property without judgment of his peers or by the law of the land. That's Article 2, right? All this other stuff is preamble. Boy, that's a huge preamble. Look at the size of it.
Really, that's a preamble?
Yeah. Well, there's sections. I guess this is for the government, to set up the government, and then this is the actual ordinance here.
Yeah, there were sections and articles.
Yeah, sections and articles, right.
That was kind of confusing.
Yeah. But this, religion, morality, knowledge being necessary to good government and happiness, means education shall forever be encouraged, but it doesn't say it's mandatory.
Right.
Anybody looked into the UN articles where it talks about healthcare and education being provided freely by the signatories of the conventions?
Article 4, the said territory and the states which may be formed therein shall forever remain a part of this confederacy of the United States of America, subject to the Articles of Confederation, and to such alterations therein as shall be constitutionally made, and to all acts and ordinances of the United States and Congress assembled, conformable thereto. And it's interesting to note that in the Articles of Confederation, it only talks about, when it's talking about United States, it's talking about the states, and when it's talking about the federal government, it says United States and Congress assembled. And here it's doing the same thing.
Could you repeat that, please?
When it's talking, if you look in the Articles of Confederation, what were you saying, Carl?
I was asking if people had paid any attention and looked into the UN Convention on Human Rights and how there are certain conventions that state that every signatory to the conventions will offer free education and free health care.
Yeah, there's. Well, I don't think the U.S. is the Universal Declaration of Human
Declaration of
Rights.
Human Rights.
Yeah, I don't think the U.S. has ratified that.
I thought they had.
Yeah, I'm not sure. But I know.
The only reason I bring it up, though, is simply because technically everybody's up in arms because of all these illegal immigrants that are coming in and getting free health care. Well, technically, they are the only ones who are entitled to it because the U.S. citizens signed up for insurance. So they're paying for it. It's their contract.
Hmm.
I just thought I'd throw that in there.
What contract?
Social Security.
Social Security.
That's included. Unemployment, Medicare, Medicaid. That's all part of, that's all part of the Social Security Act. I don't think if they were there initially, but they were added in later.
Oh, maybe it's the other way around. United States and Congress assembled is each state. It's something like that. I was noticing that here last night. I'll be back.
Yeah.
Yeah, that one thing about, some of these immigrants that have stepped up and taken the oath and gone through the whole process, being more of a U.S. citizen than people running around here saying they are, that's something else to wrap your head around.
Well, that goes right back to this then. Because if you never did that, then you're not a U.S.
No,
citizen,
you're
then
not.
you're not bound
Right, which is
to Social
why-
Security.
Which is, right.
Exactly. You know, so that the whole contract, they foisted on you with Social Security. was
Right,
fraud.
which is why, that's why the man stands up and says, I'm no longer a part of any of it, here's your freedom. That's the whole point,
As a matter of fact.
for me.
Yeah, the only problem is their evidence to show that you have the contract, social security number. They say you can't rescind the social security
Well, that's
number.
why- That's why you gotta go back to the contract. It is a contract. You weren't given full disclosure.
Right.
You were tricked into believing you were a U.S. citizen when you weren't.
Yeah.
So that right then and there, the very fact that they
And-
didn't
and-
keep,
and-
they had you for 12 years in a public school, but they could have taught you the difference between the United States and the United States of America, making you realize that you weren't born in the United States, so you're not a U.S. citizen. But they didn't do that. So that's actually constructive fraud on a
Correct.
big scale.
Right, and so if they want to push it, so now the social security number without the dashes is what I believe is our SS number, our number that tracks our, the usufruct that Boris talked about.
The QSIC numbers.
No, that's,
Something
no,